Mondays with Melissa. So this week and over the next 4 weeks, I'm going to be answering the 5 most common questions asked in elder law, estate planning, and Medicaid. So today we're going to start with question number 1, which is, can a person still sign legal documents with dementia? And that's a very interesting question because the answer is, it depends. Where most people might think that right off the bat, the answer is no, somebody has dementia, they can't sign legal documents. But it really depends on the capacity of that particular individual. The medical definition of incapacity and the legal definition of incapacity are different. So just because somebody has a diagnosis of dementia or Alzheimer's doesn't take them right out of the box as far as signing legal documents. So if we're talking about a power of attorney or a healthcare proxy, a living will, a last will and testament, we're talking to people and trying to make sure that they understand, do they know who their family members are? Do they know what they own? Do they know what they are doing essentially by signing these documents? And that's really the core of, or at the heart of, what really defines whether or not a person can execute their legal documents. You may have heard of the term a lucid moment in time. So it's very important to keep in mind that just because somebody has a diagnosis, that doesn't mean that they can't do their estate planning and they can't get their things in order. And of course, you want to do it with them as soon as possible, if there is a diagnosis, because you don't want to have to, not be able to do it down the road because of decline, because obviously those diagnoses don't necessarily improve, they get worse. So, of course, if there is a diagnosis of an early stage or an early onset, you want to make sure you're getting these documents done right away. But again, just the idea of diagnosis, that does not knock somebody out of the box for setting up their estate plan. Now, if we meet with a family, if we meet with an individual and we determine, they really don't have the capacity to sign documents, they really don't understand who their family members are, what rights they're giving, not necessarily giving up, but what they're giving a power to somebody else to do. They don't understand what it is that they have or what they own. Then we have to look at, potentially a guardianship proceeding where the family would petition the court to appoint a legal guardian for the individual because they don't have a power of attorney, they don't have a healthcare proxy, and now they no longer have the capacity to sign one. So somebody has to be able to step in to help manage things for them, and the only way to do that at that point in time is with a guardianship proceeding. So again, can somebody execute legal documents with a diagnosis of dementia? The answer is, it depends, and it is really going to be case by case, but don't just say forget about it because there's a diagnosis. It's important to still have the conversations and see if it can be done. So that's question number 1. Come back next week for question number 2 on the list of the top 5 questions asked about Medicaid, estate planning, and elder law. We'll see you next week.